A warm welcome to one and all the distinguished participants and the fellow IPs. Good evening, everyone. On behalf of IPNet Central Region, as you are aware, IPNet is hosting its 73rd webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without going further, it's my pleasure to invite Mrs. Tina Saraswat Pandey, member of the Central Zone, to deliver the formal welcome address. Madam.
Good evening, everyone. I welcome you all to today's webinar on handling delayed and complex claims from legal perspective and practical implication. I would like to thank our speakers, Rahul Parsuram Puria ji and also Ms. Babita Jain, for accepting the invite of the IPNet for enlightening us on the practical issue. So without waiting much, I will welcome the anchor to take the show forward. Thank you, sir. Welcome.
Now I request Mrs. Sucheta Gupta to play a short video showcasing IPNet's purpose, initiatives, and contributions. Mrs. Sucheta, please.
But Sucheta ji nahi hai. I'm just sharing the video. Okay.
Please.
As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
I now invite Mr. Sanjeev Chowdhury to introduce the first speaker, Mr. Rahul Parasuram Puria, advocate.
Thank you, sir. So today's first speaker, Advocate Rahul Parasuram Puria, law graduate with multiple professional qualification and the co-founder of PPA Legal, Advocates and Solicitors. He is an expert in corporate matters, looks after litigation and other matters. He has practiced as a company secretary initially. Thereafter, after 9 years continuous practice, he started exclusively with legal activities as a lawyer. So, with Beyond litigation advisory work, Mr. Prasrampriya holds leadership roles in several professional bodies, including Executive Committee member, NCLT, Advocate Bar Association, Kolkata. Executive Committee member of Direct Tax Professional Association of Kolkata, Committee member, Insolvency and Bankruptcy Committee, Association of Corporate Advisory, and active member of Tax Association of Bengal. Without taking much of time, I immediately right now call to sir to get expert knowledge on his subject, sir. Sir, Rahul sir, please start.
Sir, we are grateful to have you with us.
Yes, sir.
Our
Thank you so
speech
much.
is now yours.
Thank you so much. I hope I am audible.
Sir,
Yes, sir.
very much audible, sir.
I am just very sorry for some background noise because I don't know somebody in my above office. There is some construction activity which is going on. So I think this needs to be adjusted because I have requested them though. So, but still, I'll try that that thing is possible. So, thank you first of all, IPNet for giving this opportunity. So, I think I'm doing it for the third time, fourth time. I think for your region, I'm doing it for the first time. So, since I'm based out of Calcutta Eastern region, so I have done multiple times here. So, thank you once again for having me on this. Today, what we are discussing, the subject which basically is the subject matter of discussion, is a very important subject in CIRP and maybe in the overall insolvency ecosystem. So the name of the topic is basically handling the delayed claims. So see, as a RP, it is very important process when we are getting into the process as soon as after the admission order is passed. And the RP, before starting with my session, just I would like to clarify that I'll be focusing mostly on some judicial aspects of this particular claim portion, the determination of the and the process of handling the claim and how this process needs to be taken care by the RP as well as the liquidator during the liquidation stage as well as in the CRP stage, because there are a lot of issues which crept up and which bothers the IRP or the RP or the liquidator throughout the process. सो आपका 2 साल 3 साल प्रोसेस चल रहा है, कोई कोई इस तरीके के क्लेमेंट होते हैं जो आपको पूरे प्रोसेस में अच्छे से काम नहीं करने देते हैं. उनका ऑब्जेक्टिव ही है कि आपको सीओसी को प्रॉपर से होल्ड नहीं होने देना. उनका ऑब्जेक्टिव ही है, they might be having any other objective, we don't know because we are not discussing that. But there are situations, there are certain miscreants, if I can say so, whose overall objective is something else from that of a resolution of a company. This is one of the case. And there may be a situation where genuinely one of the claimant or maybe one of the party who wants to be part of the CSC or who wants himself to be part of the waterfall mechanism during the distribution stage finds himself in a difficult situation to satisfy the RP or the liquidator so that he is placed better in a CIRP and in a liquidation. So what I'll do is, because the time given and time available for me is very limited, मैं ट्राई करूंगा कि सीआरपी और लिक्विडेशन का दोनों एक साथ ही कवर करें. बिकॉज सी वेरी इंपॉर्टेंट इज कि वी हैव टू फिल्टर आउट गार्बेज इन एंड गार्बेज आउट यहाँ पे. सो ये प्रोसेस आरपी के लिए, लिक्विडेटर के लिए इज वेरी इंपॉर्टेंट. बिकॉज अगर कोई भी एक इनकरेक्ट क्लेम is admitted by the RP, then what will it lead to? It will lead to the constitution of a wrong COC. There will be a wrong voting share because the voting will be accordingly held. Then there will be a failure of a resolution plan feasibility because the objective of one set of creditor may be different from that of another set of creditor regarding the solvency or regarding the solution of that corporate debtor. And another thing, while we speak about the liquidation stage, what will affect the incorrect claim will be the distribution waterfall mechanism. That any other claimant who should have been better positioned at the upper stage in a waterfall mechanism, due to the incorrect call of the liquidator or say so of the RP, has been defined of his position and has been placed below. So these are the broad factors which basically affects the process, both the CRP as well as the liquidation process. So we have to be clear in our mind that we have to, very important step which the RP has to do is claim. And this is a major role or very important role both for the RP as well as this. And see, there is a distinguished feature of power and the functions of the RP with that of the liquidator. See, we all know we are a seasoned professional and now IBC is also maybe I think very 10 years old down the line, that since then we are doing it the IBC. So the role of a RP, we everybody know, is not of an adjudicator. उसको एडजुडिकेशन नहीं करना है वहां पे, उसको जो आएगा उसको कोलेट करना है, चेक करना है, वेरीफाई करना है. But there is again a thin line of a difference, and there are a lot of judicial order which crystallize the position of the verification and the collation of claims. So we'll get into that. And when it comes to the position of the liquidator, there are certain powers associated to the liquidator, given to the liquidator, because see, liquidation में क्या है, आप फाइनल स्टेज में आ गए, वहां पे लिक्विडेटर को पावर इसीलिए भी ज्यादा दिया गया बिकॉज दैट इज अ पोजीशन वेयर द एंड इज कमिंग टू, बिकॉज वहां के बाद आपको डिस्ट्रीब्यूशन ही करना है. सो द ऑब्जेक्टिव ऑफ लिक्विडेशन इज डिस्ट्रीब्यूशन, and the objective of a RP while settling the claim during the process is for the CIRP, वहां उसको resolution खोजना है. So that idea a professional who is looking after the claim, who is dealing with the claim, have to bear in mind कि किस stage में वो किस claim को कैसे कर रहा है. अब now, as I already discussed, that a wrong claim will affect the COC. Similarly, a wrong claim in the liquidation will affect the waterfall mechanism. And in CIRP, if a claim can be revised further by a claimant, so it is a dynamic position and it can be revisable. But in liquidation, it becomes more conclusive, because suppose आपने claim file किया and the liquidator had proceeded further, there is a sale of lot of assets, then the distribution has to be done. There are situations where part distribution happens, not at a single go. If one asset is realized, the liquidator distributes that amount and then apportion that figure from the liquidation cost and expense. So it is more conclusive determination for the liquidator in the liquidation stage than compared to a RP in a CIRP stage. So the legal basis coming forward in a CIRP is section 18, section 21 and section 25. And liquidation majorly covers with section 38 to 42. So I am not coming to the legal aspect very much, because a lot of legal principles, judicial principles have been cleared by now, even by the Supreme Court, that a resolution applicant takes company free from the past claim. ये हमको पता है, clean slate theory. This is a very developed principle and everybody knows. आज के डेट में जो resolution applicant है, they are also very educated. उनको भी अच्छा है. पहले होता था कि रेजोल्यूशन एप्लीकेंट को कोई तरीके से मॉडिफाई और कोई क्लेमेंट को वो चीज, बहुत तरीके के सिचुएशंस होते थे. बट नाउ everybody working in this ecosystem is having a good knowledge of the system, because it is a 10 years old. आज के डेट में सोशल मीडिया है, प्लस न्यूज़पेपर्स है. आज देखोगे हर न्यूज़पेपर आप उठा के देख लीजिए, आईबीसी का तो न्यूज है ही है. आप कोई भी बिजनेस न्यूज़पेपर उठा, तो द नॉलेज सिमेंसेशन इज वेरी हाई कंपेयर टू आईबीसी और जीएसटी. ये दो सब्जेक्ट का अगर मैं बोल लूं तो ये लोगों को अब नॉलेज अवेयरनेस हो गई है. फिर देयर इज अगेन अ बाइंडिंग नेचर ऑफ अ प्लान, दैट ऑल द क्लेम्स नॉट इन द प्लान स्टैंड्स एक्सटिंग्विश्ड. तो ये सब दिमाग में रखते हुए को एक आरपी को काम करना है. बिकॉज देखो, अगर एक बोनाफाइड आदमी का क्लेम अगर वो एक्सटिंग्विश हो जाता है तो दैट इज वेरी पेनफुल. See, painful both in terms of, maybe we say in terms of the process as well, because he will be deprived of his genuine right. Because there are situations जहाँ पे हम लोगों ने देखा, एक एनक्लेट का जजमेंट है, मैं जस्ट अभी आपको बताता हूँ. एक एनक्लेट का, I have carried it down. What is the name of that? It is a very recent judgment. I am coming. हाँ, एनक्लेट का. That is the judgment of रीना वर्सेस रविंद्र कुमार मिंटू 2015 का है. अब वहां पे क्या सीआरपी कमेंट्स हो गया था और home buyer has failed to submit their claim within the stipulated period of time. Maybe because of he is having not a knowledge of anything. The resolution plan was approved by the COC. During the subsequent proceedings, the reconsideration of the plan in 2024, the applicant sought inclusion of their belated claim. So now what the NCLAT has held? The NCLAT has held that the claim acknowledged in the corporate debtor's own record cannot be rejected solely on the grounds of delay. अब एनक्लेट जो है थोड़ा सा लीनियंट व्यू लिया फॉर द होम बायर्स. क्यों? बिकॉज वो बोल रहा है कि जब कॉर्पोरेट डेटर के बुक्स में खुद का रिकॉर्ड स्पीक फॉर इटसेल्फ कर रहा है, खुद के रिकॉर्ड में ये हमको पता चल रहा है कि वहां पे क्लेमेंट का बुक्स लेजर खड़ा है, अभी उसको होम बायर को घर नहीं दिया गया, वो एडवांस में खड़ा है पेमेंट. सो दैट कैनॉट बी अ सोल ग्राउंड फॉर रिजेक्शन ऑफ अ बिलेटेड क्लेम. फर्दर व्हाट द ट्राइब्यूनल हैज ऑब्जर्व्ड, The tribunal observed that the procedural lapse in filing claims cannot extinguish a substantive right. तो as soon as an agreement for sale is entered as a home buyer, अगर आपका agreement for sale enter हो जा रहा है, तो you get a substantive right in that property. मैंने ऐसे ऐसे केसेस किए हैं जहां पे पैसा भी पूरा चला गया है. आई एम हैंडलिंग केस, अभी करेंटली भी एक हैंडल कर रहा हूं मैटर, जहां पे 100% पेमेंट चला गया है एग्रीमेंट फॉर सेल का, बट अनफॉर्चुनेटली रजिस्ट्री नहीं हुई और कंपनी जो है सीआरपी में चली गई है. अब इट इज नाउ द ओनर्स ऑफ द आरपी टू टेक द पोजीशन ऑफ दैट यूनिट, बिकॉज अभी तक बुक्स में जो टाइटल है वो तो सीडी का ही है. आप पैसा 100, मैं सपोज कर, संजीव जी सपोज करिए 100% पैसा दे दिए उसका, एग्रीमेंट फॉर सेल भी रजिस्टर्ड है, बट टाइटल अभी भी सीडी का है. और बाय द टाइम टाइटल ट्रांसफर होता, रजिस्ट्री होती और वो एडमिट हो गया सीआरपी में. तो अब देखा जाए, अब क्वेश्चन ये अराइज होता है कि वेदर हम उसको आईएम में लेंगे कि नहीं लेंगे, वेदर हम उसको क्या करेंगे. तो बहुत सारे क्वेश्चंस होते हैं. अब दैट विल अगेन बी अ सब्जेक्ट मैटर ऑफ अ लिटिगेशन, बिकॉज सी आरपी चाहेगा नहीं कि वो अपने ऊपर हेडेक ले, वो अपना डिसीजन ले, बिकॉज दैट विल बी अगेन सब्जेक्ट, वी ऑल नो वी आर सब्जेक्ट मैटर्स ऑफ आईबीबीआई ऑल्सो, अगर कोई भी डिसिप्लिनरी प्रोसीडिंग्स है. सो व्हाट अप्रोप्रिएट वेज टू फाइल एप्लीकेशन बिफोर द एनसीएलटी, वहां से ऑर्डर लो, और अगर वो बोलते हैं आईएम में इंक्लूड करना है या फिर एग्जीक्यूशन ऑफ द रजिस्ट्री, तो वो एज ए एप्लीकेंट फाइल करना पड़ेगा कि भैया मेरा क्लेम है, मैंने 100% पेमेंट दे दिया, मैंने एग्रीमेंट फॉर सेल को ऑनर किया है, बट क्योंकि हम रजिस्ट्री करते हैं बाय द टाइम में सीआरपी में चला गया कंपनी. तो देखा जाए तो सब्सटेंटिव राइट अभी भी जो है आपका डिराइव कर लिए. व्हाई? बिकॉज यू हैव ऑनर्ड द एग्रीमेंट फॉर सेल, but title is still in the name of the CD. So what you have to litigate is only to get the title from the CD and show the bona fide of your transaction कि भैया मैंने ये good faith में किया था. So just a little diversion from the topic. So what I was saying is the tribunal observed that a procedural lapse in filing claims cannot extinguish a substantive right, especially where the debt is already admitted in the debtor's account. So इससे हमको ये समझ में आता है कि ऐसा क्लेम जो डेटर के अकाउंट में करंट लेटेस्ट बुक्स में अगर वो एक्नॉलेज्ड है, तो वहां पे देयर इज नो स्कोप फॉर द आरपी टू गेट इनटू द डिटेलिंग ऑफ द सेम, बिकॉज डेटर खुद वो करे. बाद में आप वेरासिटी जो करोगे दैट इज अ लेटर स्टेज, बट दैट मे बी एट द स्टेज ऑफ अ लिक्विडेशन. बट अभी prima facie you have seen that that is acknowledged by the debtor's book, so you have to accept the same. So since the home buyers are identified creditors, the exclusion of their claim would result in grave justice. So this was some, and we everybody know कि थोड़ा सा कोर्ट का जो lenient view हमेशा रहा है इन home buyers की तरफ में, और रहना भी चाहिए, because home buyers have invested a very hard earned money on, there are a lot of people who may be looking for just that one particular home, और वही घर उनका जो है अब वैसा नहीं रहा, तो there are a lot of things. So that again is a very different subject matter of discussion. So now coming to another case, यहाँ पे एक एनक्लेट का जजमेंट है. This is again a very recent December 2025 का जजमेंट है. I am coming to only the findings of the case because the paucity of time. So what the NCLAT has held, NCLAT clarified that the resolution professional does not possess adjudicatory power to determine the contractual dispute. अब इसमें क्या था, एक कॉन्ट्रेक्चुअल डिस्प्यूट के अगेंस्ट में अनक्रिस्टलाइज्ड क्लेम आरपी के पास फाइल किया गया था. अनक्रिस्टलाइज्ड क्लेम मतलब दैट वाज अ स्पेक्युलेटिव क्लेम कि अगर ऐसा होता तो मेरे को ये क्लेम मिलता. उसके बेसिस में डिमांड नोटिस और सारे चीज सर्व हुए थे, और वो जो है क्लेम जो है आरपी ने रिजेक्ट कर दिया था. अब उसी चीज को अगेंस्ट में एक एप्लीकेशन एनक्लेट में फाइल हुआ, एनसीएलटी में हुआ, देन इट वेंट टू द एनक्लेट. सो एनक्लेट हेल्ड दैट द क्लेम वाज फाइल्ड आफ्टर एन इनऑर्डिनेट डिले ऑफ 458 days. Thereafter, what the subject matter which the NCLAT has dealt is that the RP does not possess adjudicatory process. अब वो ये देखने नहीं जाएगा कि आपका वो एज आर्बिट्रेटर नहीं बैठेगा कि दोनों पार्टी के बीच में सुलझा कराने के लिए कि ये डिस्प्यूटेड है, ये क्रिस्टलाइज्ड क्लेम है, ये अनक्रिस्टलाइज्ड क्लेम है. दैट इज नॉट द रोल ऑफ द आरपी, बिकॉज अगर आरपी वही करेगा तो हु विल कंप्लीट द प्रोसेस ऑफ द कॉर्पोरेट डेटर. सो द NCLAT has specifically held that not the possess the power of adjudicator to determine contractual dispute. वो सब आरपी का काम नहीं है. और टू क्वांटिफाई डैमेज, अब कितना माल डैमेज हुआ, कितना क्या हुआ, ये सब आरपी का काम नहीं है कि उसको क्वांटिफाई करेगा. द ट्राइब्यूनल फाउंड दैट द आरपी acted within the scope of his duties and the timeliness while rejecting the claim. So this was held in the favor of the RP कि वो जो है
सर केस टाइटल भी बताते जाइएगा.
हाँ, केस टाइटल इज सर CSA कॉर्पोरेशन प्राइवेट लिमिटेड वर्सेस राजीव भटनागर. आई विल सेंड ऑल द जजमेंट. आप मेरे को अगर एक ईमेल आईडी व्हाट्सएप में यहाँ दे दोगे तो मैंने जो जो जजमेंट्स अभी रिसेंट जजमेंट, देखिए जजमेंट्स तो बहुत है बिकॉज ये तो बहुत क्रिस्टलाइज्ड इशू है, बहुत अप टू अ सर्टेन एक्सटेंट. सो आई विल सेंड ऑल द PDF फाइल्स एज वेल, SCC ऑनलाइन कॉपी. Sankaran ji, you are telling something. I think you are on mute.
Timelines under regulation 12 mandatory or directory, sir?
Sorry?
Timelines.
Yes, I'll come to that.
Submission of claims.
Yes. See, for verifying the claim, now it is very mandatory with respect to that in the regulation. Because just let me open. See, there are two things. Regulation 12, one is the benchmark is the approval of resolution plan. So if after plan approval under section 31, a new or revised claims are generally not entertained, because we already know there are judgments of the Supreme Court, that clean slate theory. So what regulation 12 says, if I may just read regulation 12. Yes, I'm just reading regulation 12. So now submission of proof of claim, the creditor shall submit a claim with proof on or before the last date mentioned in the public announcement. So it is, the word is shall. Then provided that the creditor who fails to submit a claim with proof within the time stipulated in public announcement may submit his claim with a proof to the IRP or the RP as the case may be up to the issue of the request RFRP. Okay. Or 90 days from the insolvency commencement date, whichever is later. Provided further that the creditor shall provide reason for delay in submitting the claim beyond the period of 90 days from the commencement. So you have to say with the delay. So now subsection 2 has been omitted, that has been substituted and thereafter omitted. Now subsection sub rule 3, where the creditor is a financial creditor under regulation 8, it shall be included in the committee from the date of, because we all know about that particular aspect if that is an FC. So regulation 12, if I may break it down, the time limit for submission claim is originally 14 days from the public announcement, and thereafter now it has been permitted that within 90 days from the insolvency date it can be filed. So now what is the main question which is there then? If a claim is filed after 90 days, whether it shall be rejected. So that is the question. So now that is not rejected because we everybody know that आपका रेजोल्यूशन प्लान जब प्लेस हो रहा है COC के जिस मीटिंग में, उसके 7 दिन पहले तक आप क्लेम ले सकते हो. So that we everybody know that there has been a verification of claim. If we can see 1C, there is an amendment that the interim resolution professional or the resolution professional as the case may be shall intimate the creditor within 7 days of the categorization thereof under 1B and provide reason for such claim which has been claimed as non-acceptable or collation. Further, now it is the duty of the insolvency professional to put up the claim which has been received before the COC in the next meeting for its recommendation, and also the resolution professional has to seek condonation of that delay with the adjudicating authority. तो अब ये जो है ना काम जो डिले करने का, बिकॉज देखिए जहां पे कॉन्डोनेशन ऑफ डिले है तो वहां पे आप देखोगे तो एक तरीके से डायरेक्टरी भी है, बट बिकॉज कॉन्डोनेशन ऑफ डिले क्यों आता है, जब हम लोग इनकम टैक्स का GST का अपील फाइल करते हैं तो वो दैट इज अ मैंडेटरी टाइम लिमिट, तभी कॉन्डोनेशन की बात आती है ना कि आप अगर इससे ज्यादा अब करोगे तो देयर हैज टू बी अ स्पेशल पावर which has to be exercised from the court for allowing the condonation. नहीं तो condonation का बात आएगा ही नहीं ना अगर डिले, अगर डायरेक्टरी नहीं. So that is the reason the condonation comes in. और अब ये देखोगे condonation जो है ये काम दे दिया है RP को. When we will see this regulation 13(1)(b) and 1(c), that is very clear कि वहां पे RP को ये ड्यूटी फॉलो करना है. I think Babita ji will deal with that aspect more once we are through with respect to this thing. So there is lot of thing. And मेरे हिसाब से देखा जाए तो ये दो वेरी इंपॉर्टेंट रोल है आरपी का. एक तो मेरे हिसाब से रोल है टू परस्यू POFE ट्रांजेक्शन, दैट इज अ वेरी इंपॉर्टेंट रोल फॉर आरपी, एंड अनदर इज दिस क्लेम, बिकॉज आई हैव सीन अगर एक भी रॉन्ग क्लेम है या फिर किसी जेन्युइन पर्सन का क्लेम नहीं आता है, तो वो बेचारा जो जेन्युइन पर्सन है उसको पूरा लास्ट तक फाइट करना पड़ता है, वो सुप्रीम कोर्ट तक फाइट करता रहता है वो अपने क्लेम को रजिस्टर कराने के लिए, और अल्टीमेटली वो हाथ धो बैठते हैं मैटर से, और बीइंग अ वेरी जेन्युइन ऑल्सो। तो अब इसमें क्या है, मैं आपको जैसे स्टार्टिंग में ही बताया था, द ऑब्जेक्टिव ऑफ द क्लेमेंट कैन बी डिफरेंट इन एवरीथिंग, बट अल्टीमेटली सी वी आर बाउंड बाय पेपर्स। तो हमको जो है वो पेपर पे रिलाई करना पड़ेगा, व्हाट इज देयर इन ब्लैक एंड व्हाइट, वी हैव टू सी दैट एंड वी हैव टू एक्ट accordingly. So that is very important, and the RP is bound by that. So now coming back to another judgment, that is again state of Tamil Nadu का एक जजमेंट था जहाँ पे गवर्नमेंट का क्लेम था अगेंस्ट द लिक्विडेटर ऑफ नागा नतना मिल्स प्राइवेट लिमिटेड। अब व्हाट इज द फाइंडिंग देयर? अब यहाँ पे ये बोला है कि वंस द लिक्विडेशन प्रोसेस रीचेस फाइनलिटी, it cannot be reopened to entertain belated claim. So this was again a very recent judgment which went to the NCLAT. So NCLAT has specifically held that time is the essence of IBC. तो आप अगर बहुत लेट आ रहे हो, लिक्विडेशन में डिस्ट्रीब्यूशन हो चुका है वाटरफॉल में, और आप उसके बाद क्लेम फाइल कर रहे हो, तो द क्लॉक कैन नॉट रन अगेन बैकवर्ड। तो यहाँ पे ये ऐसा चीज है, बिकॉज सी अल्टीमेटली IBC इज रनिंग एट द मेन पिलर विच इज द टाइम that you have to, though in the holy spirit of law we are not able to do justice because of a lot of hiccups, but still the endeavor of the government, endeavor of the RP, endeavor of the IBBI, endeavor of the NCLT, everybody endeavors to do justice to the process in a timely manner, but we everybody know that there are a lot of practical difficulties associated with it and that cannot be overlooked. So that is the reason there are a lot of judgments. The reliance has been placed in Surana Industries to hold that the equitable consideration cannot override statutory timelines. Even if you have a very genuine claim, but since you have approached it late, आपको timeline को override करके you cannot again be made a claimant in section 53. So it is a very harsh, maybe if we can say so, from the point of view of the claimant, कि अगर थोड़ा सा आपको ट्रेन पकड़ने में लेट हो गई, तो आज हम ट्रेन पकड़ने में लेट है तो आपके पास कोई ऑप्शन नहीं है, आपको छोड़ना ही पड़ेगा। सो दैट इज द ओनली रीजन। वहां तो फिर भी है कि आप वो ट्रेन छोड़ के दूसरा ट्रेन पकड़ सकते हो, बट आपको तो दूसरे ट्रेन में भी आप चढ़ोगे तो आपको टिकट तो दूसरी ही कटानी पड़ेगी, आप वो टिकट में चलेगा नहीं। तो दैट इज द थिंग। सो अगेन देयर वाज अनदर जजमेंट जहां पे क्या हुआ था, एक मैटर सुप्रीम कोर्ट जाके, सुप्रीम कोर्ट हैज रिमांडेड दैट मैटर बैक टू द NCLT ओनली फॉर सर्टेन एक्सटेंट की रेजोल्यूशन प्लान को खाली इस पोर्शन के लिए मॉडिफाई किया जाएगा। आई एम नॉट गेटिंग क्या पोर्शन था वो, बट द ऑब्जर्वेशन ऑफ द सुप्रीम कोर्ट वाज अ लिमिटेड रिमांडिंग बैक ओनली फॉर दैट पोर्शन, वो ऑर्डर में मेंशन था। अब उस स्टेज में क्या हुआ, वापिस से RP के पास प्लान आया, RP को COC मीटिंग होल्ड करना था और सारा चीज करना था। तो अब उस प्लान में जब वो वापिस से रिमांड बैक हुआ मैटर RP के पास में, तो उस समय कुछ एक क्लेम आए RP के पास में। सो कैन एनीबडी से व्हाट इज द ड्यूटी ऑफ द RP? अब उस समय RP क्या करेगा? जस्ट कैन एनीबडी जस्ट से, जो वो पीरियड रिमांड बैक वाला पीरियड था जो COC ने सुप्रीम कोर्ट ने पावर एक्सरसाइज करके दिया, सो व्हाट फॉर अ लिमिटेड कंसिडरेशन, एंड इन दैट पीरियड कोई क्लेमेंट को पता चला, सुप्रीम कोर्ट का वेबसाइट देखा, पता चला अरे भाई ये तो वापस से RP के पास आ गया है, तो उस समय वो क्लेम फाइल किया, तो क्या वो क्लेम माना जाएगा?
Not at all, sir.
Anybody else?
Yes, sir, I believe because the resolution plan is yet to be accepted.
No. See, what has been held यहाँ पे, अब that matter went to the NCLAT. वो क्या हुआ, पहले RP के पास गए, RP ने उसको रिजेक्ट किया, उसके बाद वो अपील फाइल किए NCLT में, देन फिर NCLT से NCLAT किया। अब NCLAT क्या बोला है, लेट अस स्टडी। The tribunal observed that the remand of the resolution plan by the Supreme Court was for limited issue, does not revive or reopen the concluded claim submission stage after the CRP regulation. तो जो सुप्रीम कोर्ट का ऑर्डर था वो ओनली कोई एक दो क्लॉज को लेके था रेजोल्यूशन प्लान का, विच वाज हॉन्टिंग, कि इसी को आपको वेरीफाई करना है। सो दैट वाज अ वेरी लिमिटेड ऑर्डर एंड द सुप्रीम कोर्ट इन अ वेरी स्ट्रिक्ट सेंस हैज गिवन दैट ऑर्डर कि ओनली फॉर द लिमिटेड पर्पस। सो दैट लिमिटेड पर्पस ऑर्डर which has opened that order and cannot open or cannot reopen whole CRP regulation process. So the tribunal emphasizes that the time bound nature of the IBC and the CRP regulation must be respected to maintain the certainty and finality in the insolvency process. The delay in filing the claim went beyond the procedural oversight and was not excusable, especially in the light of completed. Because देखिए सुप्रीम कोर्ट ये नहीं बोला कि तुम वापिस से आईएम करो, तुम वापिस से क्लेम लाओ, तुम वापिस से होल्ड करो. सुप्रीम कोर्ट बोला खाली ये वाला कोई एक क्लॉज है, आप उसको रिविजिट करो, सीओसी के साथ बैठो, डिस्कस करो और समझो. So that was a very limited remanding back which was done by the Supreme Court. So that is the reason you cannot reopen the whole process once again. And that too when a Supreme Court is ordering you to do so. तो आपको जब सुप्रीम कोर्ट ही दे रहा है तो सुप्रीम कोर्ट सुप्रीम ऑफ ऑल एज वी ऑल नो आर्टिकल 141. सो उस केस में यू कैनॉट रन द प्रोसेस ऑल थ्रू आउट. सो अल्टीमेटली आपका कितना भी मेरिट्स में क्लेम हो दैट स्टैंड्स रिजेक्टेड. सो दैट वाज द basically the idea of with respect to the claim on the part of the Supreme Court. So then we have seen a lot of judgments of there are supporting principles जो हम अभी भी देखते आए. Swiss ribbon में already है that IBC is a beneficial legislation aimed at resolution, not liquidation. So the procedural timeline should not defeat the substantive right. तो before plan अगर कोई भी चीज है तो उस समय तो देखिए RP is free to take a lenient view अगर प्लान प्लेस होने के पहले. बट प्लान प्लेस होने के बाद बिकॉज देन व्हाट हैपेंस सेवरल फैक्टर्स कम्स अप. उधर क्या है, आपको आरए के साथ फिर बैठना पड़ता है, आरए प्लान को रिवाइज करेगा, आरए ये आईएम में डालना पड़ेगा आपको. तो देयर आर लॉट ऑफ थिंग्स व्हिच हैपन. सो दैट इज द रीजन इट इज वन हैज टू सी. और हम लोग को भी ये इंसॉल्वेंसी प्रोफेशनल का भी आजकल आप देखोगे बहुत सारे इंसॉल्वेंसी प्रोफेशनल एंड इट हैज बीन मेड कि यू हैव टू राइट इट डाउन टू द क्लेमेंट. इनकम टैक्स जीएसटी हम लोग लिखे, पहले ऐसा नहीं था. बट आप देखोगे मेजरली, मैं तो जो मानता हूँ मेजरली जो सफरर है इसमें आज के डेट में, आप देखोगे डिपार्टमेंट का क्लेम ज्यादा है, वही सबसे ज्यादा परेशान कर रहे हैं आज के डेट में. आप इनकम टैक्स जीएसटी देखोगे, मैक्सिमम मैटर हर कंपनी के मैटर में उन लोग कहीं ना कहीं क्लेम कर रहे हैं और प्रोसेस को डिले कर रहे हैं. ये बोलते हुए भी खराब लग रहा है कि गवर्नमेंट का ही एक विंग है, एक तरफ तो एक सेंट्रल गवर्नमेंट चाह रहा है कि आप प्रोसेस को जल्दी बढ़ाओ, और वहां पे उन्हीं का एक विंग है, मे बी बिकॉज ऑफ लेस नॉलेज और मे बी बिकॉज ऑफ वट एवर रीजन मे बी, बट दे आर अल्टीमेटली वन ऑफ द मेजर पार्टी इन लिटिगेशन ऑन दिस सब्जेक्ट. जहां पे क्लेम की बात है कि आप देखोगे आउट ऑफ 10 मैटर्स 7 और 8 मैटर्स में जहां पे क्लेम जो है वो है. अब कुछ हद तक आप देखो इन दिनों में देयर हैज बीन स्ट्रीमलाइन टू दिस थिंग्स, बट अदरवाइज they are a major party to litigation in this particular thing. And ultimately there are a lot of things also because they also have to do their part. They are also answerable to their higher authorities. So there are a lot of things which comes up. So if any question I can take up by the time, because
Sir, how should an RP, resolution professional, document rejection of claims to avoid future litigation?
see, ultimately everything is now on mail. Everybody know because most of the claimant is mostly now claiming everything on mail. So that is the reason that you being an RP, first you have to forward the whatever the claim is received, you have to check it with the suspended management कि ये क्लेम आपके पास आया है. You have to sit with the suspended management, you have to visit to the corporate debtors office, you have to check their books of accounts, whether they are keeping at multiple places, whether any books of accounts has been withholded by any of the parties, any of the suspended director. So that is very important role to involve a suspended management while a very claim verification stage. Because see, ultimately you are a guest at that point of time when you are verifying the claim. आप तो as a guest अभी हो, you have not got the control of that everything because you are in a process of getting a control. तो आपके पास कंट्रोल अभी आया नहीं है, तो यू आर ए गेस्ट. आप हम भी किसी के घर जाते हैं गेस्ट के, तो थोड़ा देर जाते हैं, अपनापन जब कंफर्टेबल होते हैं तब हम बोलते हैं ना, पानी लाओ, ये करो. सो दैट इज द थिंग कि वन you start as a guest, then you become a kind of a maybe a symbolic owner of that CD. So you have to get in touch with the suspended management and try to dig out as much as information with respect to that claimant, and that information will help you to build up your case before the NCLT if that claim is rejected. And you
in case he rejects, okay.
Yes,
In
yes,
case he
please ask.
rejects, RP rejects, sir.
हाँ.
Sorry to interrupt. In
Yes,
case he
yes.
rejects the claim, how to document it, sir? You have to substantiate the reason, no?
No. See, ultimately, the reason has to be substantiated. That you are saying it is very important. So you have to categorize whether the rejection was claimed with respect to the category, whether it was on the basis of the amount admitted, whether it was a time barred, whether there was a document deficiency. So there are different headings under which you have to reason your claim. See, there may be a situation that somebody has filed a claim without a complete set of documents. Say, suppose with respect to your flat booking, he has filed that he has made 100% payment, but agreement for sale is not there. So that is the reason. So without agreement for sale there, how can you think that whether that payment is on account of a flat or whether it is just a simple advance? So documentary deficiency is one of the reason. Then there is a time barred. That is again another reason whether the debt is time barred or not. Then whether there is any dispute, say suppose for an amount of a claim, any litigation is pending before any court of law. It can be any court of law, whether arbitration pending, whether civil suit pending, whether criminal matter pending, whether 138 pending, it can be anything. So we have to check that what is the reason. So as I discussed, if it is an undisputed, it is a disputed claim, so you are not an adjudicator. You cannot adjudicate a matter which is pending before the arbitrator, where there is a counter claim and a claim which is already pending. The things are going. So how can you adjudicate that claim? So that has to be a contingent claim then. So that is one of the reason. Then it is not a debt at all. Suppose कोई ऐसा payment है जो debt ही नहीं है. So there may be a surprise people coming and claim कर रहे हैं वहाँ पे. So there are a lot of things, and ultimately what you have to, for your reasoning, you have to keep the record reconciled. You have to cross check the documents. You have to ask for the questions from the claimant, and that is everything, sir.
Okay, sir. Thank you.
So any other question, because I may have to leave after 5 minutes because I have a physical session as well, another here. And I think my time is very limited. I have also requested Babita ji to start early. And,
Sir, a very small question.
yes, sir. Yes, sir.
RP received a claim during CRP
Okay.
from a company.
Okay.
CRP taken period of 3.5 years.
Okay.
After 3.5 years, resolution plan has been approved by Honorable NCLT. By that time, the
Okay.
claimant company undergone into CRP,
Okay.
and their CRP has been completed before distribution of this claim, this money.
Their CRP is not completed.
No, their CRP is completed.
Okay. The claimant CRP is completed. Okay.
Claimant CRP has been completed,
Okay.
and new management had taken charge, and all this happened.
Okay.
So what this RP has to do with their claim in this CRP, in his CRP?
See, if new management has come in, so you mean to say that whether the claim gets extinguished or not in that sense?
Yeah.
Exactly. So see, what I believe is that the claim will not get extinguished, because see, ultimately you have to check the plan, or whether it was a going concern sale, or whether what information that RP has given to this RP. That, because see, it is the duty of the claimant's RP to inform to the CDO that now this company is into the CRP, and now I will be the contact person, or maybe so I will be pursuing this claim. And whether we have to further check also whether that claimant who is undergoing a CRP was part of the COC of this CD or not. Because see, आप जो क्लेमेंट कंपनी है वो सीआरपी में चली गई, आप ये बोल रहे हो, तो क्या वो एफसी था?
उसकी सीआरपी नो इट्स ऑप्शनल क्रेडिटर.
ओके, इज ऑपरेशनल क्रेडिटर. उसकी सीआरपी कंप्लीट हो गई, आप बोल रहे हो?
नया मैनेजमेंट आ गया उसके यहाँ.
हाँ, नहीं, नया मैनेजमेंट आ गया तो वो जो प्लान दिया था वहां पे, वो प्लान में तो ये वाला बात डिस्कस किया होगा.
नहीं, ये चीजें तो होती नहीं ना सर प्लान में. क्लीन स्लेट प्रिंसिपल चलता है वहां.
हाँ, नहीं, क्लीन स्लेट प्रिंसिपल चलता है, बट वहां लाइबिलिटी तो एक्सटिंग्विश हो गई सर. यहाँ तो अपने को तो पैसा मिलना है ना. आपका क्लीन स्लेट इज बेसिकली विद रिस्पेक्ट टू द आइटम पॉपिंग अप की, जहां पे कोई आपका क्लेमेंट आ रहा है, कोई आपसे क्लेम मांग रहा है, बट यहाँ पे यू हैव अ राइट, देयर आर सिचुएशंस जहाँ पे आर्बिट्रेशन अवार्ड है, उसका एग्जीक्यूशन पेंडिंग है, वो भी जो है कैरी फॉरवर्ड है।
हाँ,
तो
NRR है, वो सब तो है।
हाँ, तो यही सिचुएशन हमारे स्टेज में है कि यहाँ पे आपका क्लेम है तो दैट इज अ रिसीवेबल। अब पीयूएफई में भी तो यही होता है ना कि हम तो कर देते पीयूएफई, बाद में फाइनेंशियल क्रेडिटर या तो कैरी डाउन कर रहा है या तो रेजोल्यूशन एप्लीकेंट कैरी फॉरवर्ड कर रहा है। तो देयर आर सिचुएशंस विद रिस्पेक्ट टू दैट, सो आई बिलीव दैट दैट क्लेम विल स्टिल गो ऑन and the ultimately beneficiary will be the new resolution applicant, because ultimately उसका जो risk और reward है that has to be borne by the resolution applicant, मतलब claimants का जो resolution applicant है, so that will go into the resolution applicant's hand.
And 43 and 66 and that case has been handled by the financial creditor.
हाँ, वो तो सर है वो
So this OC claim,
हाँ,
I have to pay to the CD or to the financial creditors of that company.
this OC's claim will go to the OC's account only ultimately,
Okay.
whosoever it may be in the management that point of time. See, because this company, the corporate debtor, has nothing to do in toto with respect to the management change of your claimant. अब आज हो सकता है कि हम, आप एक बार सीआरपी का बात छोड़ दीजिए, मेरी कोई एक कंपनी है, मैं अब इसको बिजनेस हो सकता है मैं सेल कर दिया, शेयर होल्डिंग बेच दिया, तो मैंने तो उसकी पूरा एज एसेट्स लायबिलिटी सारा चीज सेल किया ना।
Okay.
तो उस सिचुएशन में तो ऐसा नहीं है कि मैंने राइट वेव ऑफ कर दिया।
Sir, I have a small query. Rahul ji, I have a small-
Yes, yes, yes.
yeah. So in one of my case, I have been reappointed as RP, and the
Okay.
process has been rerun after 4.5 years
Okay, so you have to again run the clock.
because the plan was not approved by the COC. Now after the liquidation amendment, so NCLT has passed a order that COC, sorry, the company has to rerun, CRP has to rerun. So
Okay.
Form G has been published as of now.
Okay.
Earlier, PF claim was rejected by the erstwhile RP.
Okay.
But after the recent amendments, should whether I can now again adjudicate or accept the claim of PF or not?
See, on what basis was that rejection done?
So I have no idea because the contempt application was filed against the erstwhile RP. He was not conducting the COC. So, but I have got the claim forms from the PF department now. After seeking directly from the PF department, they have submitted me the claim form submitted to the
नहीं,
erstwhile
see,
RP.
आपको जो वापस से प्रोसेस दिया गया है, सो यू डोंट हैव टू गेट प्रेजुडिस्ड बाय द एक्शन परफॉर्म्ड बाय द अर्लियर आरपी। आपको तो उसका दिमाग में, बिकॉज यू आज को आपको अपने फ्री माइंड से काम करना है, यू हैव टू टेक योर ओन कॉल, यू आर नॉट बाउंड बाय वट एवर द अर्लियर आरपी हैज डन, बट इट इज वेरी इंपॉर्टेंट सिंस द अर्लियर आरपी हैज ऑल्सो अप्लाइड हिज माइंड। तो फॉर योर सेक आपको उसका भी जो डॉक्यूमेंट है या जो वो चीज है वो आपको एक बार स्टडी करना इज वेरी इंपॉर्टेंट कि ऑन व्हाट बेसिस दैट रिजेक्शन वाज डन before you arrive at a conclusion.
Okay, but if I'm not wrong, there is a recent judgment by the NCLAT Delhi where it said the RP once the decision has been passed. If I'm not wrong, it is the LNT judgment, Phoenix versus LNT. If correct me if I'm wrong, where it is, so it was a case of home buyer. In that case, the claim was earlier accepted by the erstwhile RP, and in that case, the new RP when he stepped in, he checked with the gross negligences, so he denied the claim of the home buyer. That home buyer moved to the NCLAT, first NCLT, then NCLAT. NCLAT gave a decision that once the just one claim has been accepted or admitted or rejected, RP himself cannot re-verify that claim,
No, but RP himself.
re-adjudicate that claim,
No,
basically.
RP himself means that particular RP in person itself. But
Okay.
your case, you as a RP have been again ordered to rerun the process.
Okay.
So that means the NCLAT is very aware of the fact that the everything which you will decide will be through your application of mind. बट आप वो एनक्लेट जो बात कर रहा है, सपोज एक आरपी, ये तो लॉ में भी है, एक बार आप अप्रोबेट कर सकते हो तो यू कैन नॉट रीप्रोबेट। सो वी ऑल नो कि वंस यू अप्रोबेट एनीथिंग यू कैन नॉट रीप्रोबेट। तो बट यहाँ पे एनक्लेट ने आपको एक स्पेसिफिकली ऑर्डर दिया कि आप इस प्रोसेस को वापस से रन कीजिए। यू आर आस्किंग फॉर अ क्लेम वंस अगेन, आप तो वापस से हर प्रोसेस को नया कर रहे हो ना।
Claim basically, I was not asking for the claim. So I was basically because मुझे अपना claim list का डाटा तो बनाना ही होता है. So I
हाँ
seeked I shoot a mail to every the operation creator available and the financial creator, operation creator. I shoot a mail to everyone that one of the contempt application is pending before the honorable NCLT against the erstwhile IP. I'm not having any documents of the claim. You're requested to kindly send me the document,
फर्दर
and
डॉक्यूमेंट्स.
further please note that this is not a re-verification of claim. It is
हाँ
just for taking on record the earlier claim filed by you. So everyone every
नहीं,
statutory
जब आप इस लाइन पे मेल किए हैं, तब तो फिर आपका फिर एक्सेप्ट रिजेक्ट का बात ही नहीं आया ना, बिकॉज
वही
आप
कह
तो
रहा हूँ
खुद.
बट
हाँ
आफ्टर द रिसेंट अमेंडमेंट जो हम पीएफ के ऊपर आ रहा है, तो मेरा प्लान ही है बाद में एट अ लेटर स्टेज, आई एम डाउटिंग कि बाद में एट अ लेटर स्टेज इफ पीएफ कम्स इन तो वो प्लान रिजेक्ट हो जाए, तो व्हाट शुड बी माय प्लान ऑफ एक्शन इन दिस.
नहीं, देखिए आप प्लान ऑफ एक्शन आपका बाद का आप सोचोगे तो उस सोच के हम लोग ठीक है, बट सिंस आपका जो
बिकॉज इट इज अ
ईमेल जिससे.
पीएफ अदरवाइज तो
हाँ,
बेसिकली आई एम कंसर्न फॉर द पीएफ ओनली, अदरवाइज आई एम
नहीं,
नॉट.
एक बार मेरे को अंकुर जी वो समझना पड़ेगा, मतलब मे बी वी कैन टेक इट ऑफलाइन. आप अगर मैं
ओके
आपको नंबर दे
प्लीज.
देता हूँ तो एक बार हम लोग इस चीज को डिस्कस कर सकते हैं. इट कैन बी एन इंटरेस्टिंग इशू, मे बी लर्निंग फॉर मी एज वेल. मैं एक बार नंबर यहाँ पे डाल देता हूँ, तो आप जो है एक बार हम लोग इसको कर लेंगे, बिकॉज एक बार वो आपका ट्रेल पढ़ना पड़ेगा. और वो ऑर्डर इज वेरी इंपॉर्टेंट कि जो आपका जो ऑर्डर है जहाँ पे क्या रोल आपको स्पेसिफिकली दिया है, बिकॉज यू आर इन चेंज ऑफ अ न्यू आरपी, प्लस आपका प्रोसेस आप बोल रहे हो वो रीरन कर रहा है. तो आपका स्कोप और वो सारा चीज एक बार देखना पड़ेगा कि वेदर द अर्लियर टास्क इज बाइंडिंग अपॉन यू और नॉट. तो ये इज वेरी इंपॉर्टेंट. सो वी कैन डिस्कस सर.
It is always binding on the RPM. I
हाँ
think
नहीं नहीं, बाइंडिंग है,
क्योंकि
बट
CRP cost has to be borne by the
हाँ
ultimate.
हाँ 100. तो दैट इज व्हाट मैं बोल रहा हूँ कि वो ऑर्डर इन स्पेसिफिक एक बार पढ़ना पड़ेगा, जिससे कि आपका रोल और हम लोग को क्लियर हो. और
Please.
देखिए पीएफ तो हमेशा, ये मैं आपको जैसे बस स्टार्टिंग भी बोला ना, गवर्नमेंट डिपार्टमेंट ही वन ऑफ द
ये कह रहा हूँ
मेजर
कि
रीजन है
because
टू
if it is
डिले.
not a PF, because I have also received claims from GST department. I am not
हाँ
bothered much for the GST, but I am मतलब bothered for the PF only. क्योंकि PF एक
वो
मतलब
मैं
waterfall mechanism
बिकॉज
53 से बाहर होने के बाद ना.
आई एम एडवाइजिंग लॉट ऑफ आईपीज यहाँ पे, जिनका मैं ओवरऑल प्रोसेस एडवाइजरी है, बट मैं देखा हूँ कि डिले करने वाले लोग ही माने आधा से ज्यादा ये सेंट्रल गवर्नमेंट डिपार्टमेंट्स ही है, और इनका कोई ऑप्शन भी नहीं है. सो आई थिंक दैट इज ऑल फ्रॉम माय साइड. आई
Sir,
नो
in
इट इज
the
वेरी
Thank you all.
लिमिटेड.
Thank you.
इनफैक्ट
sir,
मैं.
in the interest of time,
यस
may I request you to kindly conclude this point so that we can accommodate the interactive session as well.
यस सर. सो व्हिच पॉइंट यू आर सेइंग?
No, since the interest of time is actually the time is now already
Yes, yes. So that is the reason I have just
with this
concluded. I have
point,
already.
and so
I
that
have
we can
No, no,
invite questions.
I have already concluded, because I have one another session on physically here, so I have to just leave. That is just next to my building. So
Right, sir.
maybe sir today for I'm just apology, because a very short time. In fact, I myself is not satisfied at a very limited time, and it is like a drop in the ocean, because see IBC discuss करते हैं और हम लोग ये तो ऐसा चीज है कि एक टॉपिक एक दो दिन ले ले, इतना बड़ा चीज है. So thank you.
Thank you, sir. Rahul sir, for sparing your valuable time and guiding us, enlightening us.
Thank you, sir. It was wonderful for me as well, sir. It was a very wonderful. I think Tina ji is there, or I think everybody is left.
No, no.
Sir, thanks.
So thank you, sir. Thank you, Babita ji. Thank you,
Thank you,
Ankur ji.
sir.
We'll get in
Thank
touch.
you, Rahul ji. Nice to meet.
Thank you, sir. Thank you.
I invite Ms. Sucheta Gupta to introduce next speaker.
Sir, Sucheta is not there. She has some personal problem.
Okay. I invite the next speaker, Ms. Bhavita Jain, advocate. She's having more than 20 years experience with Sri Bhavani Paper Mills Limited, a company listed at Bombay Stock Exchange, as heading corporate affairs, legal and taxation head. Presently practicing as corporate consultant and advocate in corporate matter before NCLT and NCLAT. Expertise in RBI and DGFT, Import Export Matters, Companies Act, 2013 and applicable corporate laws, SEBI rules and regulations, listing regulations, regularly appearing before National Company Law Tribunals and preparation of petition, pleadings, and other drafting in IBC and corporate law matters, etc. Handled many CIRP cases as resolution professional and as consultant and advocate to resolution professional. Presently, major case of Gangotri Enterprises Limited. Now the virtual stage is yours.
Thank you, sir. Thank you, Sankran sir. Thank you, Sanjeev sir. Thank you so much. Thank you, Ashish Makhija sir, for choosing such a very interesting topic, that is handling delayed and complex claim under IBC on the perspective of IPs as well as from advocate. First of all, I just say this is the handling the claims is the pillar of time-bound resolution. This the IBC is the pillar of this is built on time-bound process. Everything is on round the clock. The CIR, it involves often a tug of war between speed and rights of the creditor. Has been a tug of war between them. Handling delayed and complex claim is perhaps the most litigated aspect of IBC. I just say first of all, I just brief out as such, all are there on batch. They all are the respective IPs. They all are aware, but I just want to reiterate the relevant CIRP regulations for this. Regulations and IBC code. We have whenever our IRP appointed or RP appointed, we have process begin with the public announcement. We have a standard window of 14 days. Creditors expected to file their claim within 14 days appointment of RP. Now we have grace period of 90 days in regulation 12. If the creditors missing initial window, they can submit the claim within 90 days, sir, from IBC concern. Now there is regulations 12 says there has been amendment that the creditor who failed to submit the proof, they can submit the date of issue of RFRP. From the up to the date of RFRP, they can submit the claim, or 90 days, whichever is later. That window of 90 days comes to 105 days because RFRP is being issued round about 105 days. If RFRP is issued earlier, little bit earlier, in any case, this is the last day of filing RFRP issuing, then the window will final window will come to the 90 days. 90/105 days window is there. That beyond that, when the creditor in case if the 90 days after, if financial creditor is included within 90 days, that will become the part of the COC, and decision taken by the COC shall not affect the validity of decision taken earlier. Now, regulation 13, if we come, that is the verification of the claim. Verification claim, RP has to verify the claim within 7 days and compute the list. There is if RP is not able to collate the claim within 7 days, then there has to be reason thereof. There is one more regulation is there, that in the event the claim received after this 90 days or 105 days window, the interim resolution professional within 7 days of claim, he categorized the claim, and then it plays before the COC meeting as per regulation, newly amended regulation 1C, 1B, 1C. And that within 7 days, that has to be placed before the COC, and with the recommendation whether they are inclusive in the list of creditors or treatment and resolution plan, if any. Such claim then will be placed before the adjudicating authority for condonation of delay. Now, condonation of delay, now that goes to the NCLT. The adjudicating authority can can grant the condonation of delay. That there is the major reasons as such provided to us are this is unaware of the proceeding or any other sufficient cause. This is not a matter of right. This is matter of not right. This is the condonation of delay. This is only that depends upon this all depends upon the mercy of the tribunal on getting sufficient cause was not submitting the claim within 90 days, then they can give us further time subject to the recommendation of approval of the COC and being placed before the this adjudicating authority thereafter. As we are aware of in Ghanshyam Das Mishra and RPS Infrastructure versus Mukul Kumar, as Rahul ji has also informed, has apprised the same. Once the resolution plan is approved by COC, there is no fresh claim will be entertained in any case, even if they are legitimate. That is being clear. All claim, clean slate principle, all claim. Once the NCLT approves the resolution plan, all claim not included in the resolution plan get executed. Now we are coming to the category of complex claim. Complex claim involves the amount, but they are not easily quantifiable and and are legally disputed. This require RP to move beyond bookkeeping into the realm of best estimates. Contingent, there come, I just brief out. Contingent claim, unliquidated damages, liquidated statutory dues, and intercompany related party debts. These are the four categories of debt. That is being the very, these are the complex, they comes under the category of complex claim. We are now we come to the contingent claim. RP may not reject. These are the liability that comes out of the future event, pending on arbitration, bank guarantee that has not been quantified. RP must not reject simply because they are pending. The RP must make best estimate of the claim. Often RP admits at a nominal value of 1 rupee to keep the creditor's right alive without disturbing the COC's voting right. Now, unliquidated damages. These are the unliquidated claim for unliquidated damage like break of contract. When the amount has not been decreed by the court, treatment RP cannot adjudicate the claim, as we all are aware of it, unless there is submission of liability or court order. Or these claims are often set aside or admitted at a nominal value until and unless the competent court decides the amount. Statutory dues. The most disputed part of Rahul has also pointed out, the tax authorities file often late. These are the internal, they reason give internal administrative delay. Current stand is that when Supreme Court in its rainbow officers, some statutory dues which are secured, defined that waterfall mechanism is still prioritize the debt. Treatment under pending assessment, contingent claim, confirmed dues, operational debt, rainbow paper shift. Supreme Court in rules out that if the statute creates first charge on the assets of the government may be treated as the secured creditor. Intercorporate deposits, oblique related party, that requires forensic audited. Intercorporate deposits party debt, this claim which requires forensic auditing. Isn't there a sham transaction maybe to dilute the COC as well? There may be something likewise. Now we come to the verification and adjudication. It is vital to understand the difference between RP authority and liquidator. Primary role RP and liquidator both. Primary role of RP, verification, check the claim against the record. Adjudication, liquidator for adjudication determines the final amount of the claim. Power, RP has administrative power, cannot act as judge. Liquidator power is quasi-judicial, can accept or reject the claim. Appeal, creditor can appeal to the NCLT against RP's rescission in RP, against the RP. And creditor has a statutory right to appeal under section 42. Now, there like intercorporate deposits may, the complex claim between the related parties requires there is not a SAM company or in internal transactions are there to dilute, manipulate the COC voting. The best practice for RP to issue the formal notice of rejection or notice of discrepancy. However, in my case, I always issue acceptance oblique rejection within 7 days or asking for some additional information. This is best practice for RP to issue a written communication, email, something likewise, that your claim is accepted or rejected. Notice of discrepancy can also be issued. That is Otherwise, there may be unnecessary litigation will be there on the part of the claimant. In case if debt is visible in the company's balance sheet, RP should not admit it. As such, until and unless we have Form B, Form C, Form D is there. There is another problem arises before RP. We have always have a problem that a treatment of claims which are time barred under limitation. So, a time barred under Limitation Act and received by the insolvency professional within the timelines provided by under IBC code. These regulations framed there. Various legal provisions are there in connection with. Section 3(6) of the code says right to claim as right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. We can say claim need not be legal. Time barred by it may be noted that we can say claim need not be legal, claim barred by law. Limitation are nevertheless defined as claim under the code. Such claim even be disputed. The main point is that if we see the definition 3(6) of the code, this clearly says claim. There is no provision in whole IBC Act which says that the claim are to be legally enforceable, legally enforceable or within limitation or any other objective to be mentioned therein. Then I understand that the claim may even disputed. They are disputed, undisputed, legal, equitable, secured, and unsecured. The 4-5 points under section 3(6). 3(8) again defined corporate debtor, corporate person who owes a debt to any person. Here is also there is no concept of limitation is there. Section 311 says means the liability or obligation in respect of which claim which is due from any person. Then it has been seen that the word debt is not qualified by the word of limitation, adjudication, enforceable. Nothing likewise is being mentioned. Section 330 defines secured creditor as means a creditor in favor of whom security interest is created. Even then, sometimes this Section 7 petition of the bank barred by limitation. But when the CIRP is being admitted on any other creditor, then we can file the claim before RP. And RP claim, whether it is enforceable within the limitation or not, that doesn't make any difference. Financial creditor, the definition, if we see the section 5(7), any person to whom financial debt is owed and includes excesses. 5(8) also defines means debt along with interest, if any, which disbursed against the consideration for any time value of money and includes so and so. Here it speaks the time value of money and it is being disbursed. Now, limitation point of view is nowhere is being pointed out. 521 also speaks on the outline of the operation debt. There is nowhere enforceability is being pointed out. I have not seen in anywhere in that. Section 18 defines the duties of the RP. We have seen that its clause we direct him or her to receive and collate all the claim. It does not ask him to decide legally or otherwise or for what it would be beyond his scope. Supreme Court has also made it clear RP has administrative power, not quasi-judicial power. Adjudication authority, it has order for calling the claim. They are not saying enforceable claim. They always order, call for claim. 238A of the courts specify provisions of Limitation Act as far as apply to the proceedings or appeal before adjudicating authority. Then the section 7 and 9 application whenever we make, then before the adjudicating authority, then it will absolutely clear so far as it apply to the proceedings or appeal before the adjudicating authority, not to the before RP, provisions of liquidation, this limitation. If we see section 35(1)(a) of the code, liquidator has both powers and duty to verify the claim. 39, 40, 41 direct the liquidator to verify the claim and find the value thereof and admit or reject to them. Such power of liquidator can be said to be of adjudication under section 41. Hence, under section 41, creditor aggrieved by the he can make appeal to the adjudicating authority. CIRP Regulation 13 doesn't talk of verification of the claim, but doesn't give him power to admit or reject the claim, whichever certainly prevails over it. Overriding power of Limitation Act is so far as it only before the NCLT, NCLAT, DRT, DRAT. Word liquidator or RP doesn't appear herein. These express provision of limitation is applicable. There is no word of RP or liquidator appearing in section 238, 238A as well as under the Limitation Act. Resolution professional and liquidator wears different caps and processing the claim however it appears. It as far as until now we have made the discussion on account of limitations and definition of the claim. It appears that the intention of the code is not to make Limitation Act applicable for processing of the claim during CIRP. The RP in accordance with the code and relevant regulation is empowered to collate and verify claim, but not to adjudicate the issue. Such claims, such as claimant, if their financial creditor will entitle to be a seat in COC, it is left open for resolution applicant in their commercial wisdom to decide how much amount to offer to each creditor by making the decision of liquidator in respect of acceptance of claim appealable before adjudicating authority. Liquidator is mandated to not to accept the time barred claim. Such aggrieved claimant can seek the relief from the adjudicating authority for time barred claim accepted by the liquidator. The other successful claimant can also impede themselves as it affects the entitlement under waterfall mechanism. As regards the liquidation, it is not feasible and acknowledgement and not advisable for RP to seek acknowledgement of debt towards ascertain if limitation stands extended. It is not enforceable to check all the circumstances. Being an RP, this is not feasible for us. To every claimant, we ask them to produce the acknowledgement of debt. Is rather a trustee of all stakeholders. RP is being the trustee of all stakeholders, not the COC. The democratic structure giving power to COC to decide the resolution plan. Decide the resolution plan. This doesn't mean the other persons have not the power. In such case, all COC which are not the party to the application, they may get time barred, but they can file the claim and become the part of the COC as well. There is the few judgments. I think most of that they are very popular judgment. Supreme Court in Committee of Creditors and Satish Kumar Gupta. Role of resolution is adjudicative, not administrative in nature. These Supreme Court emphasized that the RP act as facilitator, not the judicial authority. He is tasked with collating and verifying the claim, managing the process, and then preparing information memorandum, but not ruling on merits of the individual claim. This distinction limits the RP authority to reject the claim on legal grounds. Supreme Court again in Ghanshyam Mishra and Sons, this is very Edelweiss matter. Once the resolution plan approved, all claims which are not the plan of the part of the plan is extinguished, and no person will be entitled to initiate, continue any proceedings regarding a claim which are not the party of the resolution plan. This affirms the finality of the resolution plan. Clean safe principle we are saying. Including those, these are include the all time barred as well as disputed claim which have been admitted during CIRP. Weekend educational, that was also matter. That limitation of process is applicable. Article 137 of Limitation Act is applied. But this judgment settled the confusion over retrospective applicability of provisions of the IBC is not told to revive the time barred debt. Court held limitation is a procedural law, applies to all applications under IBC from code inspection. Even before the 238A was inserted, the case formed fundamental authority on the application of limitation before CIRP. The Supreme Court in Gaurav Hargobind Lal Bhai versus ARC India Limited. This is an application under Section 7 of IBC is covered under Article 137, which provides for 3 years limitation time from the date when right to sue occurs on the date of default. This is also one of the matter. Supreme Court in ARC versus Vishal Jaiswal. An acknowledgement is in balance sheet can amount to acknowledgement under Section 18. But if such acknowledgement is unqualified and not accompanied with the disclaimers, no disclaimer. Yes, sir. The Supreme Court resolved the key issue confirming the balance sheet and balance sheet entries can serve as the acknowledgement of debt under Section 18, thereby extending the limitation period. The NCLAT in the matter Sunil Kumar Agarwal versus Noida and others, IRP is not expected to decide the issue of limitation. The claim submitted by the creditor should not be rejected solely on the ground of limitation. It is the adjudicating authority to take such a view. This case clarified non-adjudicatory role of IRP. Oblique RP, it inserted RP cannot reject the claim on sole ground of limitation. There is one interesting case is there, IBBI disciplinary committee order in Vinex Implex Private Limited claim by Ekta Khare. In this case, Section 7 application was filed by some financial creditor, which was being rejected by adjudicating authority on the ground of limitation. However, on other financial creditor, this was admitted by NCLT, this application. And Ekta Khare filed the claim before RP and which was being admitted by RP. And despite of being NCLT has rejected their claim, but IBBI has taken as disciplinary action against the RP and suspended her license registration for 2 years period. What the law says is another point, and what the IBBI says another point. Then we have to be very cautious about accepting the claim on the basis of which NCLT has already rejected the financial petition. This is the interplay between, I have just pointed out the interplay between Limitation Act and IBC. The IB code gives the broad definition of claim under Section 36A, encompasses the right of payment irrespective of legal enforceability, and suggested the IRPs should collate all the claim, including those barred by limitation, to uphold the code objective, maximizing value and ensuring equitable shareholders participation. So this is the irony which IRP has to face it. Now, sir, we are practical challenges I have already briefed out. कि communication issue करना है, data room manage करना है, all RP to maintain RP. There is a clean slate principle also there. We should go to that become absolutely clean slate. We have to be very cautious while rejecting or accepting the claim. That is the basic foundation before the resolution plan, because every resolution plan is being prepared on the basis of information memorandum. And in case if there is a discrepancy in information memorandum, resolution plan cannot be succeed. The basic fundamental require of this IBC to revive the corporate debtor and within the time period provided, therefore that is being failed. And there is some case analysis. Rahul was in hurry case. He has to consider it. He has to apprise. But now I am just presenting. First of all, case is RPS Infrastructure and Mukul Kumar. The RPS Infrastructure submitted its claim 287 days after stipulated deadline. Resolution plan was already approved by COC. The resolution professional rejected the claim due to delay. Appellant challenged the rejection before adjudicating authority. NCLAT rejected the decision of adjudicating authority, leading to file before Supreme Court. CIRP, Supreme Court clearly held CIRP is a time-bound process. It emphasized once the resolution plan is approved by COC, No new claim can be entertained as this would disrupt the insolvency process and the judgment enforced principle that public announcement under Section 15 or Regulation 6 of CIRP regulation serve as sufficient notice to all the creditors who must remain vigilant and in submitting their claims within the prescribed period provided therefore. Again, there is and there is very important judgment, Sale Tax Officer and Rainbow Papers Limited. Appellant, Sale Tax Officer, Government Authority submitted the claim for unpaid VAT. That was of around about 48 crores after prescribed deadline. RP rejected the claim on the ground of delay. That again went out to the NCLT. Supreme Court ruled in favor of the appellant. Holding the statutory oath to the government cannot be summarily excluded. Court stated that the government, by virtue of statutory change and charge under Gujarat Value Added Tax as secured creditor under IBC, and its claim should be considered within the hierarchy of payment under Section 53. The decision created very much ambiguity as it reflected in earlier precedents where the government dues are treated as unsecured and ranking lower in priority. This now this was this review में भी गया था ये matter, but that was not what that was not being succeeded. But Supreme Court in Paschimachal Vidyut Vitran Nigam Limited versus Raman Ispat Limited has confined the applicability of Rainbow Papers to its own factual circumstances, thereby providing relief to all stakeholders, especially IP holding this liquidation or resolution process, who receiving demands from tax authorities on the strength of Rainbow Papers, issuing consideration in present matter. Paschimachal Vidyut Vitran Nigam Limited had charged the property of this Raman Ispat due to unpaid electricity dues, claimed that to be treated at par with the first priority of secured creditor and placing reliance on Rainbow Papers judgment. Whether the security interest created by operation of law can be treated. There was the main issue was consideration before the SC was whether the security interest created by operation of law can be treated at par with the first priority secured creditor under IBC, whether Electricity Act overrides the provisions of IBC. Waterfall mechanism under IBC, prioritization of claim or waterfall mechanism is one of the most important aspect of the insolvency law, wherein the secured creditor holds the priority position over operational creditors and government dues. The position was upheld by the Honorable Supreme Court in various rulings. In Monet Ispat, Commissioner of Income Tax Monet, Honorable Supreme Court held that income tax dues, being the nature of crown debt, do not take precedence over the secured debt, who are the private persons. Similarly, Moser Ware Union versus through President Mahesh Chandra Sharma versus Union of India, Honorable Supreme Court has emphasized upon the priority of the payments under IBC and held that the provisions of IBC are carefully thought out. The same gives options to secured creditor and balance of their interest with those who are the creditors in liquidation proceeding. There is the observation of the court and final verdict of Supreme Court after explaining the waterfall mechanism envisioned the IBC and judgment passed earlier under the supremacy of IBC over other laws came to conclusion that Section 53 provides the hierarchy on priority of the claims on various class of creditors. In Rainbow, the facts and circumstances are total different. That was different, and Section 53, that is waterfall mechanism, was not very much noticed by the Honorable Supreme Court. Now, it has been observed, Honorable Supreme Court also went on emphasizing upon the inclusion of government dues in lowest priority as per Section 53 of the Code, whether they are secured or unsecured, highlighting the intention of the Parliament to treat the debt owed to government as distinct from the debt owed to the secured creditors. There is the difference has been pointed out, highlighted that they are highlighting the intention of the Parliament to treat the debt owed to government as distinct from debt owed to the secured creditors. It has been observed that in Rainbow Papers, waterfall mechanism was not considered. Relevant para of the judgment I may read out. Rainbow Papers did not notice the waterfall mechanism under Section 53. The provision has been diverted or extracted in the judgment. Furthermore, Rainbow Papers was in context of resolution process, not during liquidation. Section 53, as held earlier, enacts waterfall mechanism providing for the hierarchy or priority of the claim of various class of creditor. Careful design of Section 53 locate amount payable to secured creditor, workman, second place, and all and after cost and expenses to the liquidator payable during liquidation processing. However, the dues payable to the government are placed much below the secured creditors and even unsecured or operational creditor. If we see the waterfall mechanism under Section 53, we are clear government dues, if even they are secured or unsecured, they are come at the lowest hierarchy, whether they are secured or unsecured. But the government dues are government dues, they are placed at that was being ignored in, I understand that has been ignored in this Rainbow Papers. However, the court become very cautious, and RP are also very cautious while taking this government dues claim, whether secured or unsecured, as per the circumstances arising. Sir, now I will take to the next case, CSA Corporation versus Rajiv Bhatnagar. The appellant entered into consortium agreement with corporate debtor but failed to complete contractual obligation. The corporate debtor was later admitted into CIRP under Section 9. Appellant did not file its claim within stipulated 90 days period but submitted Form F after delay of 548 days. RP initially accepted the claim but later rejected it. NCLAT upheld the rejection, stating that entertaining belated claim would derail the successful resolution of the corporate debtor. This is again adhering to the timelines. There are so in every court we are finding in NCLT Allahabad also have so many matters for auction purchaser matter. The court are not taking seriously, and they are not these matter to be decided on priority. I understand, because auction purchaser who has invested a plenty of money, lots of money in purchasing this kind of assets to be for revival, but revival is becoming more and more difficult. One of the NCLAT judgment is Standard Surfa Chem Private Limited, Kishore Gopal Sumani. Appellant was a successful auction purchaser and assets of the corporate debtor in liquidation. Appellant sought extension for making payment under during COVID guidelines. Supreme Court held timelines of the IBC are directory in nature, but certain exceptional circumstances such as COVID-19 pandemic warrant the relaxation. Such exception should be rare and justified by compelling reason. Now the judicial approach for belated claim under IBC underscores the need of a structured and predicted insolvency resolution process. Supreme Court in RPS infrastructure reaffirmed the principle that claims cannot be entertained once they have been once the resolution plan is approved, emphasizing commercial certainty. And decision in Rainbow Papers complicated the treatment of government dues, creating inconsistencies in the application under Section 50 of 53 IBC. A clear legislative framework is required to ascertain the ambiguities in the treatment of belated claims, ensuring that the sanctity of CIRP timeline is upheld while balancing the rights of stakeholders. Until such clarification made, the tribunal and courts must adopt a cautious approach to prevent dilution of IBC objective and ensuring a time-bound, efficient resolution process. I think this is more than sufficient on this type of claims. Any queries, friends?
Yeah, madam, in your experience, have delayed claims become more frequent in recent years? Delayed claims.
Delayed claims? No. Now the people are in my own experience before various NCLTs and all. Delayed claims now become less than as at the time of initiation of the IBC, at the commencement of IBC. Now the people are becoming more and more, but still there are so many cases. People either do not file their claim or they delayed filed and pressurize RP through NCLT, NCLT adjudicating authority to accept their claim after approval of resolution plan by COC. In home buyer case, this has been very frequent. One of my matter of home buyer, I was advocate therein that there was the COC has approved the resolution plan. There are 10 to 12 stakeholders went out to NCLT. Their claim was rejected by NCLT. They went out to NCLT. Then again that matter been given to remand to the COC. This should not happen, but this is happening as such. But still, nowadays, courts are very reluctant and they are not accepting the claim filed after the approval of resolution plan by COC. Yes, sir.
Is handling delayed claims more of a legal issue or a practical challenge on the ground? Is it more of a legal issue or a practical challenge on the ground?
Yes, sir. Delayed claim is not a much practical issues are there, but on delayed claim, whenever there is the contingent claim or there is if it is a standard claim, then obviously after approval of the resolution plan, we outrightly reject the claim and write down 90 days timelines are there. And after approval of the resolution plan by COC, this timeline closed. This timeline is also closed that through COC we can get it approved. But there is some complex claim. There is situation arises on account of complex claim, contingent claim, and this unliquidated damages. This is more and more pragmatic. Statutory dues. They have tremendous powers as tremendous problems as regards the statutory government claim, because they usually just say we have administrative problem, admit by claim, but after approval of the resolution plan, there are plenty of judgment. Even then, they still fight it at NCLT and all, and creates the problems in resolution plan, and delays always be there in such cases.
Can you throw some light on the judgment of in Ghanshyam Mishra case, madam?
Yes, sir. Ghanshyam Mishra judgment. Yes, sir.
On the extinguishment of claims not filed.
Ghanshyam Mishra matter was absolutely clear. That clean slate principle was given that was being given. घनश्याम मिश्रा क्लेम में क्लीन सेट प्रिंसिपल आया था और उन्होंने बिल्कुल किया था देयर इज नो पॉइंट ऑफ रिटर्न at once the resolution plan is being passed, you can't return this or there is and no claim can be given in clean slate theory was passed in Ghanshyam Mishra matter. I just pointed out. Yes, sir. Ghanshyam Mishra versus Edelweiss reconstruction plan. Once the resolution plan is approved by AA, all claims are not the part of the plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding regarding a claim which is not the part of the resolution. Ghanshyam Mishra pointed out after approval of the resolution plan by adjudicating authority. This judgment firmly established the finality of the approved resolution plan by the adjudicating authority. It underscores the need of all the creditors, including those time-barred, disputed, to submit them during CIR. Fail to submit the claim during CIRP. Failure to do so result in permanent extinguishment. Whether it is this case reinforces the necessity of comprehensive claim collation by the RP.
Okay. Thank you.
Thank you, sir. Anything else, sir?
Any questions from the participants? It is.
Please. That is, today's topic was very interesting and quite
Yes.
RP's interest. And thank you so much, sir. I do not find any.
Thank you,
There's
ma'am.
a problem in
Any
this.
questions? Any
Sir, I
questions?
have a question here. I have a question.
Yes, sir.
Hello.
Hanji, sir.
Yeah.
Yes, sir.
So in case of EPFO, let's say if the claim comes to me, and like claim comes to me maybe after 6 months of the start of CIRP, and
Yes, sir.
moreover, if when I ask for the evidences, so they are not able to provide employee-wise details of their claim. And secondly, whatever claim is there, so the proceedings of that very claim have been done after the ICD, like 7A order is there, 7A proceedings are there, or maybe some kind of interest or damages have been levied, or the assessment is done after the initiation of that is the, I would say, ICD, which is the corporate insolvency initiation. So that is actually done after that. So there are no demands. There are no demands raised by them prior to ICD. All the demands raised by them and the assessments done by them or the proceedings done by them are after ICD.
There is one matter, Regional Provident Funds Commissioner versus Excel Glass Limited. NCLT Kochi branch का ये order है, where order passed by in IA 1258. The proceeding initiated or continued against the during moratorium period will be considered as offense. They can't initiate any proceeding. If they have claim, they have to inform us. They have to inform us and file the claim accordingly. Their liability, their responsibilities as such, they can't commence with the assessment after initiation of the SSCIRP. This EPFO always creates a trouble. Likewise, in one of my cases also, they are creating such kind of trouble, but we have given them reply accordingly. We have provided them, you can't initiate assessment as of now. This monet is part order also. There is the Supreme Court has override that the provisions, they can't initiate any proceedings before after initiation of CIRP. But they can file a claim along with the list of employees accordingly. There are so many judgments. Regional Provident Fund Commissioner EPFO versus Rajan Resolution Professional of Kemaya. Also there is, and this is RPFO, and this is clearly claim lost its legal validity when the IBC prevail over all other laws as defined.
Ma'am, thank you, ma'am. So again, if I elaborate, actually, thing is that they are always sending me as RP. They are always sending me WebEx meetings, actually links from their side. So they do it. They have done it numerous times. So what I have attended their WebEx meetings,
Yes,
actually
sir.
conducted by their senior officers, and they
Hmm.
always say that as RP, I have to provide the records. But on my side, I have filed 19.2 application. So I do not have the employee-wise records or maybe the any other record like EPFO or maybe of ESI, PF deducted. So nothing is there. But they are regularly showing that they are in touch with the RP. They are actually calling the RP for the proceedings, and they also on their side also, let's say they have some records, employee records are there, or actually returns are filed with the department. Let's say if they file the claim and they provide some kind of employee-wise calculations to me, so would I be required to actually admit that very claim?
If they have, as per the first of all, number one question is that whether the books of account says any dues to the EPFO.
Madam, I do not have the books of accounts in my possession, so I couldn't get the same from the suspended directors.
And they are filing the claim without giving the name of the employee and as such. They have to provide.
Madam, actually, 5 of my CIRPs are going on. So in one of the case, actually, department has provided me the employee-wise details. In 4 other CIRPs, I couldn't get the details. So I'm talking of, so 4 cases are there wherein employee-wise details are not provided. In one of the case, employee-wise details are provided. Yes, those are provided to me. But in all the cases, proceedings have been done after the ICD.
But the proceedings after IBC, this is the violation of moratorium under section 74. That is really point number 7 in agar hum dekhenge to there is the EPFO judgment. There is clear point raised by the appellant and respondent need to be analyzed from the records of the two factors. The applicant, being the EPF authority, has raised certain demands which were adjudicated during CYRP period and after the initiation of moratorium, when no assessment proceeding can be continued by the applicant irrespective of whether certain documents were sought from the resolution professional. No, they can't, assessment proceeding cannot do. They can provide us, if the claim is there for certain employees, they can provide us it through the RP, and RP will collect the claim and present and incorporate it in its resolution plan.
Okay, so you mean to say that if demands are not raised prior to insolvency commencement date,
Yes, like
so
assessment. Then our responsibility is to issue the form, the form A for claim form publication, and we have published the public announcement, and they should file us the claim. And assessment right under this moratorium, at once the moratorium commences, no assessment right is available to them. They just file the claim. Until and unless they file the claim, formally file the claim, I can't accept. And I have every right to ask for details and clarification from them for keeping the claim, for asking the claim, whatever it is there.
Madam, let us say
Yeah, even there
they
in
actually, Madam, claim has to be supported by some kind of demand raised.
yes,
If
sir.
that
Yes, sir.
if that proceeding is done after the insolvency commencement date and that demand is raised after that during the moratorium period, should I accept it?
Demand raised after moratorium period cannot be accepted. But if it is genuine and for employees dues period from the date of initiation of CIRP, then we have to accept it. We have to see that X employee has to PF dues this much amount, Y employee has this much amount, Z this much amount, then we can accept it. For liquidated damages and interest part, these are not acceptable, but we have to keep it at the dues. Dues as in resolution plan, their treatment will be other. They are treating as a they cannot be, we cannot accept the liquidated damages, etc. But principal amount of PF to be accepted if it is up to the date of initiation of CIRP. But after initiation of CIRP, they have no right to commence the assessments, cannot be done thereafter.
Madam, yes, you are saying that assessments cannot be done. But
no, assessment cannot be done after if it is prior, if the demand raised prior to the date of initiation of CIRP, we have to accept that. Because
okay.
we have to be, sir, I just suggest one thing.
मैडम
This
ये
is
ना
very
मैडम
careful
ये
aspect.
आपकी ना वर्डिंग थोड़ा सा कॉन्ट्रेडिक्टरी है. आप कह रहे हैं कि assessments cannot be done after the initiation of CIRP.
Yes, sir.
ठीक है मैडम. पर एक साइड पे आप कह रहे हैं कि जो उनके क्लेम हैं अगर वो जेन्युइन है तो क्लेम वो जेन्युइन है तो आरपी है तो
असेसमेंट नहीं कर सकते आफ्टर, लेकिन उनका जो अगर उन्होंने कोई असेसमेंट पहले से कर रखा है वो आप देख के उसको
हाँ पहले से कर रखा है ना मैडम, वही मैं कह रहा हूँ. डिमांड इफ डिमांड इज रेज्ड ड्यूरिंग द मॉरेटोरियम पीरियड आफ्टर एप्लीकेशन ऑफ सेक्शन 14, सो देन आरपी शुड नॉट एडमिट द क्लेम. अगर डिमांड पहले की है so then RP has to admit.
डिमांड पहले की देन आरपी हैज टू एडमिट. यस सर. और
क्योंकि मैडम जो मेरी अंडरस्टैंडिंग है तो
we have to be very cautious for that because PF dues have a 100% पेमेंट resolution plan में होता है. तो resolution plan में किस बार हमें IMS को स्पेसिफिकली मेंशन करना चाहिए ये PF का लेटर आए, ये this is the problem with PF because otherwise RA and court may reject the resolution plan if PF dues are not clearly provided in the resolution plan. That must be became the part of the this IM. If the demand is whether you are accepting the demand or not accepting, you are unable to collate the demand, please mention it in claim because not accepting, you are not unable to collate that, not unable to collate that demand also.
ठीक है मैडम. So I have to make it as a contingent amount in the information memorandum.
In case contingent, not contingent, you're not unable to collate that. Not accepted, not unable to collate. उनको
नहीं
clearly
मैडम,
आप लिख दीजिए, अगर employee was list there prior to the CIRP initiation का, then we can accept the claim if it is in proper form wise.
ठीक है मैडम, ठीक है. पर वो डिमांड, अगर मुझे डिमांड पहले की नहीं मिलती है इंसॉल्वेंसी कमेंसमेंट डेट से पहले की, तो
हाँ जी.
देन आई शुड नॉट एडमिट द क्लेम. वो तो
No,
क्लियर
no,
है ना?
but you must make it part of the IM also, but otherwise it may create trouble.
नहीं मैडम, आईएम का पार्ट तो बना दिया मैंने. वो क्लेम
जी जी हाँ
काफी
जी जी.
काफी हेफ्टी क्लेम्स हैं उनके, तो आईएम का पार्ट तो बना दिया. पर बात यह है कि क्लेम को मैं एडमिट नहीं, मैंने नहीं किया, मैंने रिजेक्ट कर दिया ऑन द बेसिस ऑफ सर्टेन एनक्लैट जजमेंट्स. लाइक देयर इज वन एनक्लैट चेन्नई जजमेंट, और
Yes, sir.
कुछ और जजमेंट्स भी हैं. तो उसके बेसिस पे आई हैव रिजेक्टेड दोज वेरी क्लेम्स बिकॉज डिमांड्स आर रेज्ड आफ्टर द इनिशिएशन ऑफ सीआईआरपी, दैट इज ड्यूरिंग द मॉरेटोरियम पीरियड.
Yes, absolutely, sir. बिल्कुल आप लेकिन बस ये कि अगर हम लोग उसको पार्ट ऑफ द IM बनाते हैं तो उसका लेटर ऑन द जो whatever the RA, he will take a recourse of that also, ना that amount may be provide or not to provide. This is his choice.
नहीं मैडम, आरए तो नहीं प्रोवाइड कर रहा. आरए तो प्रोवाइड नहीं करेगा. वो कोई बहुत हेफ्टी अमाउंट है. तो आरए अगर आरपी उसको एडमिट नहीं कर रहा और वो सारे के सारी असेसमेंट्स हैं ड्यूरिंग सीआईआरपी की गई हैं, तो वाई शुड आरए पे?
नहीं
आरए तो इतनी मोटी.
अगर वो ड्यूरिंग CIRP है तो आप कैसे नहीं ले सकते उसको सर.
बिल्कुल ठीक है, बिल्कुल ठीक है
जी.
मैडम.
Thank you, sir,
ठीक है. थैंक यू सर, थैंक यू सो मच, थैंक यू सो मच.
Thank you so
for
much,
the
sir.
engaging questions,
Thank
sir. Any more questions? Sir? Any more questions from any parts, any of the participants? Thank you, madam. Any final words to say on this subject, madam?
My just before rejecting any claim, they have to if at once this is their problem arises only when there is the claim when the claim is contingent government claims. RP has to be very cautious about it, and timelines provided in CIRP regulation and IBC must be adhered. Which is that's also.
Okay. Thank you.
Thank you, sir.
Clearly outlining the statutory framework. While the legal position emphasizes timelines and finality, practical implementation often presents operational challenges. Now I request to next offer the certificates of appreciation to the lead speakers.
Sir, I think we should end up this seminar because nobody is there from management side.
Thanks a lot, Babita madam,
Thank you, sir.
for
Thank you.
presenting this valuable subject among us. Thanks to our first speaker, Rahul Parasurampuri also. No, now he is not here. We are very much thankful to our president, our Ashish Makhija sir, for his valuable guidance and dedication to this IPNet. And thanks to Shankaran Saab and all others for participating and moderating the show. Thanks a lot.
Thank you, sir. Thank you, sir.
Thank you.